the first to know. Nsem-Pii TV.
Today, we'll go into the history books as one of the worst days for Sammy Gyamfi. And when you know who and chaketi kura, propaganda ni nyina eka ne yam. Emra one lawyer Gary ni Makon, MPP legal team panyini pa kon ekohia ye ewo media house in Accra. Ni nyina efa ruling na justice efiasewa asarebotwe edibetu dwa on the 2.37 million euro ambulance case involving minority leader Casey Latoforsen, businessman Richard Jakpa, and the Attorney General Godfrey Yeboadame. Immediately after the court ruling, and as usual, Sammy Gyamfi koye press conference, ko di atro, ko kekan samwa, ko ton kan nyina okokan. And the same thing, and we better TV so say I Justice Efiasewa Asarebotwe ehye Attorney General say on recuse no ho, on twe ne ho free case ni mu. Eno nti and Justice Efiasewa Asarebotwe admit the leaked tape as evidence. Ebian lawyer Sammy Gyamfi ko kan say Ghana mremu no baby ene ho no mu a ekire say leaked tape na nse say ye makwan ema ye bo en wo court. Na bo ya mo no court a Justice Efiasewa Asarebotwe admit into evidence ne kire say Attorney General no ewo pre-consumed idea se kwan bia so or the Casey Latoforsen ebetu afiase ne no na lawyer Gary ni Makon nya bre edi ni wura mremu or the way pem no no akoto ateke we no dia pem no afa die Sammy Gyamfi na say what didn't sashe the devil famu din wontumi mie na kura nkasa because once again the truth has outweighed propaganda. Once again, no kura no ato kania edi ato atro no so atro no enya baby amfaniti enwura. Enti yebeko straight ni yakwa akutie. Sadie lawyer Gary ni Makon edi Sammy Gyamfi fa mremu fa mraso ya na afedie won't be kwemi na no kase.
The issues complained of started between 2014 and 2016. These are the facts, isn't it? Right. Good. Now, something. At the time when the prosecution entered the dock, mounted the dock, led evidence in the case and everything, closed their case, the issue of so-called doctor tape had not arisen. For even backtrack, at the time when settlement conference was going on, document was being exchanged by the parties. The so-called tape had not arisen. The case closed. Submission of no case was filed by A1 and A3.
Jakpa and
Latoforsen. And this is very, very, very instrumental. The court said, no, it's a case for you to answer. Now, let me go to that point. You see, it is very, very, very instructive. Very, very instructive.
I've read the entire ruling on the submission of no case.
No, yes. It's very instructive in terms of the findings made by the court that a case has been made for them to open their defense.
Right.
So let me refer you to page.
They are only supposed to punch a small doubt
exactly
in the Republic's case, and the Republic will lose.
Exactly. Now let me go here. The judge said, and I'm referring to page 4 of the ruling that we are dealing with. He said, submission of no case dated 30th March 2023. This court concluded that a prima facie case has already been made to merit all the 3 accusations then to open their defense. Now listen, something. That the matter was settled. That the ambulances in the state in which they were delivered could not serve any useful purpose. But the assertion was made by the cross-examination and the evidence put forward, particularly A3, that there were moves to fix the defects, thereby proving the case that there was no loss occasion to the state. It means that at this stage, there is a case which has been made that the loss is occasion. But as to whether the loss is wherefore, and who caused the wherefore act, that is yet to be determined.
And I'm happy you read this portion.
Good.
You know why? Mm-hmm. Because I had heard commentaries, including respectfully from Sammy Gyamfi, right after this decision throwing out the applications. That suggested that the judge had done something in predetermining the matter.
No.
By suggesting that the state had established that the vehicles that were delivered were without useful purpose. But if you read the decision, she actually highlights this. She says the matter was settled that the ambulances, then she begins to highlight, in the state that they were delivered, that's highlight, in the state that they were delivered, could not serve any useful purpose. She did not say, emphatic, that the matter has been settled, that the ambulances could not serve any useful purpose in the state that they were delivered.
Good.
Yes, go on.
Now you see something. At this stage, then A1 now mounts the box. Leaves evidence in chief, is cross-examined, call witnesses, 3 of them, and closes his case.
Atuforcing.
Now, Atuforcing is here. He said, further, there was the issue of what authority the first accused person exercised what he asked for the LC to be issued. It is a case of the prosecution that the LCs were issued without due cause and authorization. The prosecution is stating that A1 had no authority, had no authority. He stated, among others, that the agreement that culminated in the delivery of the defective ambulances, which cannot be used in the condition that it is. Now, A1 also called the Minister for Finance, who came to testify for him, and closed his case. All these stages, there's nothing called recorded tape. You see something, and this is very instructive. Prosecutors go to court, do their investigation, build a theory of their case, take the evidence with them, put it before the judge. Just accept that there's a case for you to answer. You also come and mount your defense. A1 closes and it's off the dock. A3 now comes because A2 has been discharged. Then at this stage, you start your evidence in chief. You put your witness statement in there. And then you are now being cross-examined by counsel for A1. A1 and A3 are on the same path. And even the direction by the judge that A1, lawyer for A1 cross-examine A3, the Senate of Appeal, which they filed a stay.
Because they believe the Attorney General should do their work before they come in.
But they are on the same path. A1 and A3 are on the same path. Their interests are coterminous. All right?
So actually, for those of you who have not followed, one of the applications seeking to hold the hand of the judge not to do anything is in respect of this particular one that is pending in the court. Because they are saying that you have done something that we disagree with you. You said, you said Atuforcing's lawyers should cross-examine Richard Gyapa before the Attorney General. We don't agree with that. That's not what the practice is. So that's why one of the applications was asking for a setting stay, and the judge refused it. Yes, go on.
And even in that period they filed, they didn't particularize any particular error of law made by the judge.
We will not go there. Let's stay here.
No, you see, I'm just trying to get the public, something, you and I, and my good brother, come on, sit where you are not feeling well.
Let's stay here. Let's not attack the process on appeal.
Fine. We owe a duty, a solemn duty, to educate the public and to avoid this propaganda and the mischief and the public deception and all. You have to let the public know what are the facts of the matter, because until the press conference of the NDC that they did, I was not following this case. They brought us into this case. By now going to court to even follow the case. I have not been to court on this case before. Then we are now being told that under cross-examination by my very, very good friend Tamaklo on Gyapa, he now suggests that there's a certain tape that you are trying to contrive evidence to lie and all the blah 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 blah.
Because
this ruling,
whilst Gyapa is giving his testimony,
yes,
the Attorney General makes a certain intervention about suggesting that Gyapa is, doing the bidding of Atuforcing,
yes,
or is seeking to help Atuforcing.
Yes.
So Gyapa gets angry and then says, you have done this to me, I will spill the beans.
Yes.
And this is where we are.
So this is a beans. This is a beans, Samson. Having listened to this tape with sober ears, you will see clearly that all the statements that were being said by Jakpa did not emanate from the Attorney General saying, say this, say that, say this. It is very clear.
Why was he not protesting them?
Who was protesting?
The Attorney General. When you and I are having a conversation,
yes,
and I'm saying, you know, we have met here, you have been doing this. I'm saying I can't do this. Why was he not protesting?
You see, you will see from the tape clearly there was a disagreement about LC.
That's correct.
The age understanding of what the LC and its import meant was different from what the Jakpa was saying. And then we were disagreeing. All of a sudden, because Jakpa knew that he was recording. He knew he was recording what he was.
He started sense, but you know.
He started now suggesting things, saying things, and even dropping names. Mm-hmm. He started dropping names.
My question is, why did the AG not object to that kind of thing?
Let me tell you something.
You have said this, you have done this, you have been seeking to get me to do this.
My conference with the AG, subsequent to the leakage of this particular tape, he tells me, that, look, Gary, there is not a full tape. Mm-hmm. Because the discussion even started with the issue of me going for international arbitration and me seeking to get an adjournment because I was prepared for international arbitration. And the gentleman also having earlier on not been able to attend court, but then the bench was issued against him. And then being afraid that now if he doesn't go to court, then he may get another bench warrant. So I said, if that is so, then you have to seek for medical report. And all that portion of the discussion have been taken away.
He said,
now, what report?
He said,
hold on.
Go ahead.
What communication? Something I've known you for over 20 years. We talk. We talk on the phone. Yeah. We meet, we speak. What communication will you call me? You will not even greet me. No salutation, nothing. And all you see is that in the middle of the stream, I'm talking, or you are talking. Which communication doesn't start like that? I think that we have to approach this particular matter, and we are now, it's as if, because of an existence of a certain tape, one-sided tape which has come up, the issue before the court should be thrown away. That, because now somebody is saying that the tape exists, there is no issue about financial loss to the state, whether willful or not willful, whether the state has lost money or not lost money. Everything should be thrown away. And then we should now rely on existence of a certain tape recorded by one person to throw away the entire case, say there's a mistrial.
You know, if our jurisprudence accommodates mistrial, it doesn't mean that there will not be a trial of the case itself. Mistrial will mean that there will be a pause, and then you have to go and reassemble your facts and come back. But because of a certain development, including misconduct, it has led to, the case having to be stopped.
You will need to assess the entire case and see whether there has been a miscarriage of justice, whether there has been some contrivance or some evidence. You have to make a full assessment of the entire thing to say that, look, some injustice has occasioned the person, and therefore it's a mistrial.
Okay.
In this particular case, let's be honest with ourselves. From the very beginning of the proceedings all the way to the time Satifosi closed his case, who has introduced an issue that he has not been given fair hearing in the matter? Even when Jakpa himself started mounting the box, he had the tape with him. Indeed, the tape was there. This tape that he relies on now at this stage to try to cause confusion into all of us and to take our minds off, this tape was there. This tape, according to them, was recorded some few days or so when he had mounted the box.
The day he was going to mount the box.
So if he found the tape relevant, the tape was relevant to disproving this case or show some confusion in the Attorney General's case or whatever it is, why did he not at that time file for leave to amend the witness statement that, look, I think that this particular information is relevant to me, showing that my innocence. This particular tape, something, it's a red herring. The tape has nothing to do with whether the financial loss was caused or was not caused. And I'm surprised that this tape is now taking all of us our focus from the real issues in contention, which is whether or not somebody's act or omission advocation the republic,
We all don't
or
share
willfully.
We all don't share the same view. You heard Ansari.
Oh yes, that is
You
why.
heard him.
That is. Oh, I heard him. That is why
Let's
I'm
resign
saying.
or be sacked.
You see,
Misconduct.
that is why I'm saying that. Something. Listen, you see, we are confusing the matters. The issue about whether the Attorney General will resign or will be sacked, one lies with appointing authority.
Their political decisions.
It's a political decision. Or he himself sitting down to say, well, maybe I want to resign. Okay? The issue of whether there is even a breach of our ethics rules is not the courtroom. It's not the courtroom. That is why the judge says, I'm not to deal with this particular matter here in the courtroom.
Right.
There is no rule of law or practice
Okay.
that is dealt with in the courtroom.
Right. There's an issue that is being raised about the judge not allowing the lawyers to move their motion and to argue.
Samson, I was in court. You know, I told you that I had not been following this case, but
I was there. I was just next door. I was in the other court. I was also busy.
courtesy the NDC press conference. It made me now go to court to be listening to this particular matter. You know, just to leave everything I'm doing to just go and sit down and listen.
Right.
I was in court. Sammy was in court. He was sitting about 2 blocks from me. You know, the motion was moved. You see, I took back delivered a certain decision at the Supreme Court. And
Experts say 16 alloys.
it's in alloys.
Republic versus
Yes.
Court of Appeal, right?
Yes, it's in alloys.
What did they say?
Once a motion has been filed and all the parties have filed and responded to the application, and the date for hearing is due, the return date is due, a judge is not obliged to admit viva voce arguments in court.
You know,
The judge can rely on submission filed before the judge and determine the propriety of the application. Now, this particular one, my lord, the judge said, Mr. Tadoshori had raised a legal objection. And then we hear the legal objection because it was on a point of law. And he spoke. I was sitting there. Someone was sitting there. He spoke. Attorney General responded to the legal objection. So when they say they did the legal objection, they didn't allow them to speak. I don't understand. What I remember they saying is that they are first on process at the Supreme Court.
yeah, but the legal objection is separate from moving the motion.
That's what I'm saying. But no, why is the motion has not been moved?
Your point is that there's law that says that's immaterial.
The judge said, I'm not going to admit oral viva voce arguments in court.
Good.
But the law is settled that once the due date, the return date is due, and even if you are not in court, the lawyers are not in court, the judge is not obliged to invite you to come and the judge can look at the paperwork and determine the ruling.
Do you realize that sometimes we misapply that authority?
Why?
Because the ratio is not actually that. Why do we give a date for hearing? When you file an application, why don't we say, because you have filed it, come for ruling? Why do we give a date for hearing?
Oh, something. We all know that by practice and procedure, you file an application, the return is fixed for you, depending on number, because you must give the other side notice of the application.
Good.
I mean 3, 4, 5 clear days, depending on what you are going to do.
Right.
And the nature application that you have filed before the court, the other side responds to the application. It's on record. You go there. The judge sometimes can look. I've been in court severally. Some judges will say, Nimakon, you will not speak here today because you are going to give a lengthy submission. So you will not talk.
You
will not
we're
talk.
familiar with it.
Yes.
But I'm
So
saying
you will
that
not talk. And then they say they are going to rule based on the papers. And I sit down.
you and I have used ex parte Eastern Alloy
Yes.
to make this point on News File once, that yes, a judge has the right to go ahead and do this.
Good.
But maybe you want to go and read it again, and you find that the ratio is different. That in that case, the one who brought the application was actually not there. And then the one who had to argue the other side went ahead and did their business. And then later he goes to, the appeal,
Yes.
complaining that
Yes.
I was not heard.
And
because I didn't
the
move the
Supreme
motion.
Court said that the court has no obligation. It's not obligation. That's in the letter.
Right.
Obligation.
Is there a practice direction to the effect that when you have complicated